Do you know why, under a liberal understanding of free speech, we don't ban offensive speech? Let's ask a different question. Do you know what the first Supreme Court victory for gay rights was? The two, in the current context, somewhat ironically, are relevant to each other. Before the Supreme Court struck down restrictions on gay marriage, before it struck down sodomy laws, there was a time during which you couldn't even advocate for gay rights without legal consequences and obstruction by law. The reason was a set of 19th century morality and obscenity laws passed under the Grant administration called the Comstock Laws. Under these laws, US postal services were banned from delivering and spreading any material containing pornography, any sex toys, contraceptives, instructions and materials used for abortions, any homosexual content or material, be it pornography or advocacy of normalization of homosexuality, and even personal letters and correspondence that had sexual content. Postal services played a much larger role in the formation of public opinion and political discourse than they do today. Without the internet, TV or even radio, newspapers, leaflets and other political material were mostly spread through US postal services. And with these laws in place, the US Postal Service, and by that extent the government or whichever political party was in charge of the government, could choose to simply cast out and remove any materials from the public discourse that it deemed to be obscene. Before the Stonewall riots occurred, and before there even was a nationwide organization that one could call a gay rights movement, even before lawyers and legal professionals sought out to specifically advance a cause of gay liberation in the courtrooms, the advocates of such were mainly small groups of people acting independently by whatever means available. And one of these groups was One Inc., which published a monthly issued magazine, One Magazine, a journal advocating for gay rights, seeking to normalize homosexuality in a society largely hostile towards it. The magazine featured mainly articles and opinion pieces covering such topics, as well as personal accounts and stories by gay men and lesbians throughout the United States. And during this time, the publication of gay stories within literature was not uncommon. Especially in New York and Boston, there was a phenomenon of pulp novels published mainly containing pornographic stories of lesbian couples. What differed them from publications such as One Magazine was the moral outcome of these stories. The pulp novels ended their stories in tragedy for an overall moralizing point over the evils of lust and homosexuality. One Magazine, however, differed by publishing stories of regular gays and lesbians who establish happy relationships in secrecy or elsewhere far away from praying eyes. And it was one of these stories that got One Magazine into legal trouble. In April 1954, Senator Alexandra Wiley of Wisconsin, as part of Eisenhower's crackdown on homosexuals in civil service, wrote to the Postmaster General in a complaint of their delivering of One Magazine, which he called devoted to the achievement of sexual perversion. The magazine was evaluated by the US Post Office, and a story of a happy relationship of a young lesbian couple in their 20s was used to declare the publication as obscene and filthy. The US Post Service banned all deliveries of One Magazine to its subscribers. The owners of One Magazine decided to challenge the US Post Office decision in the courts. The case made it to the Supreme Court by 1957, who ruled in favor of One Magazine in 1958, referring to a previous court ruling, Roth v. United States from 1957, in which the court had ruled over the New York publicist Samuel Roth, who had been charged with obscenity for mailing erotic and pornographic material to buyers. In that case, the majority of the court ruled that obscenity should still be unprotected speech, but redefined it to not apply to Roth, with Justice Brennan stating, in the majority opinion, that sexual intercourse is in itself not automatically obscene, therefore art, literature and science covering sexual intercourse cannot be automatically deemed as obscene, and that public conversation about sexual intercourse has value to society. It is, however, the dissenting opinions in this case by Justice William Douglas and Hugo Black that are more relevant to the liberal understanding of free speech. Both of them were constitutional literalists, or strict constitutionalists, a legal philosophy according to which legal texts should be interpreted exactly as they are written and only focus on the text itself. The First Amendment of the US Constitution reads, "Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abriding the freedom of speech, or of the press, or the right of the people to peacefully assemble, and to petition the government for redress of grievances." No law. Being literalists, both Black and Douglas believed that this meant Congress should not enact any law whatsoever restricting speech. As Douglas wrote in his dissent, free speech has occupied an exalted position because of the high service it has given our society. Its protection is essential to the very existence of a democracy. It has been the safeguard of every religious, political, philosophical, economic, and racial group amongst us. Free speech has been the one single outstanding tenet that has made our institutions the symbol of freedom and equality. And referring to the obscenity laws, the list of books that judges or juries can place on that category is endless because what belongs on it is chosen on the basis of personal belief, taste, and moral standard. Ultimately, the Supreme Court majority rulings of both 1957 and 1958 were victories for free speech that opened to the public what could be said, published, and advocated, without fear of reprisal of being arbitrarily labeled as obscene. It is the 1958 ruling that ultimately made a gay rights movement even legally possible, because before that ruling, merely advocating for gay rights was something that could be legally shut down. The Supreme Court ruling, however, is today largely forgotten and barely celebrated or cited. The first gay rights victories in the history of the United States were free speech victories, but Black and Douglas ultimately are who we should focus on. With their dissent, they ultimately also proved to be ahead of their time and to be adherents to what would ultimately come to be our modern understanding of what free speech truly is. In the One magazine ruling, the majority opinion, by referring to the previous Roth Court ruling, ultimately was that homosexuality itself, or at the very least discussion of homosexuality, was not obscene, or at the very least not obscene enough to justify being censored. It, however, acknowledges that obscenity should be used as a legal term by which a government official or institutions within the United States could set standards by which to police speech. Black and Douglas disagreed with that. It would, however, be 30 years later, and years after both of them had died, that they would be vindicated. And here is where we come to a far more famous case.
No, Justice Scalia, I would say there is no line between the two, because really what you're talking about is a matter of taste and not law.
Discussed to this day and brought onto the big screen, when the self-proclaimed moral majority, a group of far-right evangelical preachers, gained traction throughout the United States of the 1980s under the leadership of preachers such as Jerry Falwell, Larry Flynt, a publisher of pornographic magazines, decided to publish a fake advert campaign for liquor, depicting Jerry Falwell as a drunkard who had regular sexual intercourse with his mother. Falwell sued for defamation and emotional distress damages and was awarded a substantial sum in damages by a California court. Flynt appealed and the case made it to the Supreme Court. And it was there where the court, in the famous unanimous ruling, decided that Larry Flynt's satirical piece was protected under the First Amendment. This case is often brought up as a victory for freedom of speech, as a victory for comedy and satire, that a right to lampoon public figures with obvious untruths was secured. However, often forgotten is another decision made in this court ruling. Read the arguments made by Falwell's lawyers, and you will notice something funny yet eerie. The arguments made in the defense of a right-wing preacher are similar to those made by advocates of policing speech today from the left. That certain speech is just counterproductive and therefore ought to be banned, went contrary to moral standards, that certain jokes and words did not reflect thought but only hatred, that speech causes harm, semantics over free speech not protecting bigotry, self-styling as victims of speech, recurring comparisons to Goebbels and to Hitler, classifications of certain words as fighting words, and the idea that speech causes harm and emotional distress. What Falwell, his supporters and his lawyers attempted to argue was that there was an outrageous standard, a standard of obscenity, that statements could be so outrageous that they go against a moral standard and set of beliefs held by a public majority, and therefore ought to be banned. And the response to that was that simply because a certain moral standard was held by a majority, this does not allow for that standard to be enforced upon a minority, which kind of is common sense. We don't let people force their will tyrannically on others merely because they won an election. But far more important, and at the core of this ruling, what is moral and what is immoral depends upon the beliefs, convictions, needs, desires, feelings, or even just tastes of individual people. This fact automatically disqualifies it as a universal standard to regulate speech according to what can or cannot be said on the basis of what is offensive. In other words, we don't let Falwell, Robinson, Graham, or any other past or present right-wing figure dictate to us what can or cannot be said on the basis of their beliefs, moral standards, tastes, or feelings. So what makes you think that you should?
Vox is doubling down, 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 down. YouTube community means progressive. The usual fear-mongering garbage we've come to expect.
Classical liberty.
Nobody made that case. The case against banning offensive speech. You can go through all the videos made on this topic throughout the past month, and to an outsider it will look like a campaign to sell t-shirts. The vast majority of videos claiming to be in defense of free speech are personal attacks and conjecture, conspiracies over media collaborations with no substantial evidence to them. Here's some food for thought. The right to free speech is important. How much can you trust someone who doesn't even know why though? Or at least can't even make a coherent case for why it is, or sees it as an unequally applied privilege rather than the principle. The arguments used here in defense of free speech have more in common with the arguments used by Falwell's followers and lawyers against free speech than anything else. Having watched the Carlos Maza Stephen Crowther row last month, I'm starting to think that the reason why the freedom to speak is increasingly curtailed online is not just because there are people who argue for censorship and bannings because of an offensive standard, but because the people who claim to argue against it aren't really all that much against it themselves, at least when applied to those they disagree with. Think of this in the end. The court ruling I mentioned in the beginning of this video, the fact that the US used to have laws that even criminalized the advocacy of gay rights, laws that were stricken down by the Supreme Court in 1958 because they violated the right to free speech. Well, Russia under Putin recently introduced a set of laws that pretty much are the same thing, and when they did, some of the same people, now claiming to be guardians of free speech as a principle, uploaded videos praising these laws in Russia.
As part of a monumental public relations scam. I'm not approaching this from the free speech angle.